Okay, hold on, got it. Live stream. Record to iCloud. Okay.
Great. Okay. So Doris, can we do the flag? Please?
Yes, I'm going to share that. Okay.
Flag.
All right. I pledge allegiance to the flag
Flag.
of the United
The
States.
United
States of America and to the
Republic which
and
stands
one
one
nation, under God,
God.
indivisible, with liberty and justice for all.
Okay, great.
I always feel vaguely like we should have the national anthem going along with that
Oh.
when it first comes on screen.
Okay.
We'll let you sing it for us.
All right. Well, thanks everybody for being here. It's Tuesday, April 26th, 2022. We're doing it via Zoom, the meeting, planning board meeting. We have Neil Slevin, Kay Lawson, myself, Megan Toy, Nathan Brown, and Larry Perrine, all from the board present. Also Kathy Eisman and Liz Vale. So with that in mind, the first item on the agenda is the minutes from the prior meeting. If I could get a motion to approve those minutes.
Moved.
Okay, and a second.
Second.
Okay,
Larry's
so
approve, I'll
Larry
second.
moved and Nat made a second. All those in favor to approve?
Aye.
Aye. Aye, so carried. Okay. The next item on the agenda is 100 Glover Street. This is a application proposing to subdivide a property that's in the village at that address into two separate lots. I'm just gonna.
Are you getting any audio?
Pardon?
Why am I not getting it? Yes.
Okay,
Yeah.
Ron Reed is logging in.
Okay. Bruce, can you hear?
Hi, Ron.
Hi, how is everyone?
Good. Hi, Ron.
Sorry,
Ron,
I'm
we
late.
just- That's okay.
I was
Thanks.
peeling potatoes with my son and it lost track.
Ron just missed, we just adopted the minutes from the last meeting.
Okay, great.
And then we moved on to the only item on the agenda, 100 Glover Street subdivision application.
Well, why are they not coming in on my speakers? I'm trying to figure that out.
Correct. Who's-
I think we can keep going. I mean, I don't know. What do you think, Liz? Right?
Yeah.
Okay.
Yeah, you can keep going. Hopefully Bruce can hear us. We can see him. I don't know what's going on.
So just to recap on the last meeting, the board initiated referrals. Suffolk County Planning Commission found the matter to be for local determination. Coastal consistency recommendation was approved by the Harbor Committee, and no comments came in from other referrals sent. It's a proposed subdivision is conforming. The planning board directed Kathy to circulate a lead agency coordination letter, which was sent the following day of the meeting, which was in time of the 30-day requirement. No agency objected to the planning board acting as lead agency, and the application is complete at this time. So I think the suggestion from Kathy, feel free to chime in, was that the planning board assume lead agency under SECRA, adopt the negative declaration. We can go through that form she sent out just to be sure. And then we would schedule a public hearing on the planned preliminary subdivision for the next meeting. Is that right, Kathy?
That's perfect.
Okay.
I did prepare a resolution for the board to adopt that says all of those things too.
Great.
So it's in writing.
So I think one of the things we're going to do as a board is go through some of these forms just to make sure that we are all comfortable with, adopting the negative declaration on this. So Kathy emailed out, I believe earlier today, was it, Kathy? The
Yes, yes.
short environmental assessment form, the impact assessment. So since we're lead agency, we've assumed that status. We're supposed to go through this form and, as a board, make the determination whether or not there's no or small impact under the form, or, if there is an impact, we can discuss that and see. Does everyone have the form in front of them?
Yes.
Okay.
Can you share it,
I'd
Kathy?
like to share it. I could share
Yeah.
it.
Yeah.
That's a good idea. Thanks, Kathy.
So Doris, could you allow me to share?
Of course. Okay, you're ready, Kathy.
Okay. Make it a little bigger. So as Kay had said, this is this part of the environmental assessment form is used by the agency to identify under each one of these categories whether there's no impact or a small impact may occur, or if there's a moderate to large impact that may occur, in which case there's a different decision that was made. But in this case, for each of the categories, and there are 11 of them, we identified no or small impact may occur. The two that were potentially a concern were the wetlands that are located just off-site on the public property. But that area has been delineated by Nelson Pope Quarries recently, and it's all off-site. The buffer area is within the property, and any development would need to go to the Harbor Committee for a permit in future for any improvements on the lot. And, they will require vegetation or some type of management of that area to make sure there's no impacts on the wetlands. The second, does anybody have any question about that?
No.
Okay, the second is that this is a potentially archaeologically sensitive area, and the applicant had a phase 1A, 1B prepared. The 1A is research, that they research the records and then conduct a field visit and identify whether there is if there's a potential for artifacts on the property, either prehistoric or historic. They had felt that this site actually could have the potential for some resources, but they did pit tests and found none on the site. And so the report that was received did not recommend any further archaeological investigations. So those were the two areas that could have been a concern. These are two conforming sites under the R20 district. And so moving forward, actually, in one way, they will both have to have innovative alternative wastewater treatment systems for the treatment of their sanitary waste, and that's something that they don't have on the site presently. And then the portion of the lot that has been developed in the past is a former dairy farm, is my understanding. So, and it has quite a few structures on it that will be removed. So there will be two homes in the future with sanitary systems that actually have some treatment to them.
Thanks, Kathy. So with that in mind, and does anyone on the board have any questions or want to go over any of these items in more detail?
I have some questions.
So I don't know, like everything says that it's a small impact and maybe I don't know enough, but I know Glover Street has had a lot of development in the last like 10 or 20 years, and it used to be a lot of open space. And this is a large piece of land. And I'm wondering if it does impair the character or quality of the community because I don't know, it's kind of like Millionaire's Row over there right now. So I think I hear what you're saying, Megan. I think though, keeping in mind like would be a conforming, like the two lots that are being subdivided would be conforming. And, looking at the adopted like zoning and land use for that area, it is consistent with that area. Even though I understand the emotional component of losing open space, or there's a perception of a loss of open space maybe, because obviously, there are buildings on that property now that are pretty large, like a barn and maybe two barns, which would obviously, those are going to go away if it's subdivided and then redeveloped. So in that sense, looking at the, focusing on the laws in the village and the zoning and the use that they want to use it for, it is all conforming within the code. So as a board, those are the kind of things we really need to focus on. And thinking about it in terms of the fact that other parts of it have been developed doesn't mean that this can't proceed under the code as it stands. I don't know if I put that the right way, Liz.
You did. I mean, this meets the zoning, and that's the key for a subdivision. You're creating another lot. You're not approving the actual structures on the lots. You're just creating another lot, and it conforms to the zoning, which is what the legislative board decided, basically how these lots could be carved up. And so you're here to make sure that they're done according to the code. And that's what's permitted under the code.
And
as far as the size of houses, though, that are built, that's a separate matter that's not before the board.
Yeah. So does the, because it says that the structures that are there will be demolished, are we approving that right now?
I think that's going to be a condition of approval, of an ultimate approval, from what Kathy was recommending, and that's up to the board, that the board will determine the conditions of approval. But I believe your planner is recommending that the pre-existing non-conforming structures on site get demolished. Is that correct, Kathy?
Yes, and that would be something that would require a separate approval, actually, a demolition permit. And and my understanding is that it gets referred to the ARB, even though it's outside of the historic district, but they would still review it for before a demolition permit would be issued.
Mhm.
Is this property still on the market, or has it been bought?
That's not something that this board can consider, the status of the ownership. Likewise, a lot of boards get into whether it's going to be a spec house or developed by a spec builder. That's not something that the boards are permitted to consider. It's just that it's been submitted to the board, that the appropriate owners have signed the owner's endorsements, and the application is on file appropriately, and therefore it proceeds.
Okay.
Yep.
Any other questions? Okay. Thanks, Megan. Thanks, Liz. So with that in mind, do we want to go ahead and move forward? Do we just adopt what you drafted, Liz, or?
Yes, I drafted a resolution for the board, which I sent to you earlier. Essentially, it adopts your assumption of lead agency. It resolves to assume lead agency. there's a resolve to adopt the negative declaration after reviewing the EAF, and then also setting a public hearing for this matter at the next meeting for May 24th, 2022.
Okay. Do we need to read that?
No, you just need to make a motion and then have a second and adopt.
Okay, so if I could get a motion to adopt that, which was drafted by Liz with those 3 main goals in mind.
Yeah, so moved.
And a second? Okay, who's the second? Larry?
Larry.
Just to be clear, thanks. Okay, all those in favor? Aye.
Aye.
Aye. So carried. Okay, thanks. So we will move forward with that, and I think that's it.
There'll be a public hearing on this matter on May 24th.
One question?
Yep.
Whose phone is that? Maybe just mute that.
I muted Nat.
I wanted to
Sorry,
ask,
Nat.
may I ask just one question? The
Yeah.
code says, Bruce Anderson, Self Environmental, the code says that the planning board will send written notice, but that the applicant will post the property. Is that still the practice of the board?
You know what, Bruce, I'm going to follow up with you after that,
Okay,
because my understanding is that we do the notice to the paper for the hearing, that you do the notices to the property owners,
okay, just want to make
Yeah,
sure that.
and that you also post the property.
Correct.
Yeah, I know about the
Yeah.
posting. I was just,
Yeah.
saw that in the code.
But you also do the mailings. Yeah,
So you want us to do the mailings?
yes. But we can talk about it after.
Okay, fine.
Oh, Bruce, you can contact the office. I prepare the public notices and the posters, and I will contact you when they're ready
Okay,
with the instructions as well. Okay. Thank you, Liz.
I have a question, a couple questions, which
Okay.
have, which is not on something that's before us right now, but it's something that came before us 5-6 months ago. And that is the use of the old railroad station house on the property of the Sag Harbor Garden Center, which is being proposed and being built out as a retail tasting room for beer, for a brewery. And these are my questions. One, it's a general procedural question. What's being proposed is a change of an allowed use, which is the garden center in the business district, to another allowed use, I assume, which has not been identified publicly to my knowledge. It could be within.
Sorry,
the
Larry,
building.
can I interrupt you just for a second? I just want to check with Liz. I don't want us to talk about things that we shouldn't talk about.
I think it's okay to ask questions about an application. I'd prefer not to discuss pending applications at a board meeting without the applicant present so that they could participate in what's being stated or questioned before the board. So I would advise you just to ask Kathy these questions after the fact. You can email Kathy and I, or you can call us on the phone and speak to us, or we can check with the building department to determine the status of the application right now. But I don't think it's wise to start talking about pending applications before this board with no notice to the applicant that it's going to be discussed, and also without the applicant present to present their application to the board or rebut or answer questions for the board.
Okay, that's fine.
Sure.
Then this is directed to Doris. Doris, I requested that the building inspector call me about a month ago. You remember, right?
Of course, yes.
I did not get a phone call.
Okay.
And I request that the building inspector call me.
Yep,
Okay.
we can do that.
We can do that, Larry. I can.
Then maybe Kathy could just give Larry an update on the status of that application via email? That's okay?
We can do that as well.
Okay, thanks.
I'd like to ask a question on that same theme, which I hadn't thought about it, but in my mind, in my memory, this essentially is an application that it came before us, and then it went away for reasons I can't honestly remember why it went away, and appears to be in limbo. So my question is this in fact a pending, or is that an application that's actually pending before us? And if it's not,
I believe this was done as a pre-submission conference. I don't believe that they've ever submitted anything. I don't have anything, so.
right, so we don't actually have an application.
That's right.
You may get one in the future, right?
Right.
We may get one, but I think that given the fact that they did come before us, it's not at all unreasonable on everyone's part to wonder whatever happened to that.
I think if I correctly, it was determined that it was an allowable use within the village according to the building department and I believe the ARB, if I remember correctly. So it didn't fall under our jurisdiction.
Yeah, see, there's the problem. Therein lies the problem from my point of view, just as an educational tool. If it doesn't, we need to have the opportunity to talk about why it doesn't. And is that in fact appropriate? I mean, we've all always been troubled by what a planning board actually does relative to the word planning. And the positioning of an establishment where the consumption of alcohol is going to occur strikes me, and I think strikes most reasonable people in the community, as something that ought to be planned and thought about and contemplated. Not that the other boards don't do that, but what does the planning board plan then, if not things like that? So I'm only protesting, Liz, on the grounds that they came in front of us, and it strikes me it's right to the heart of what we do if what we do does not include what we know the intention of the applicant was, which was to put a drinking establishment.
Well, why don't we, I hear where you both, I hear Larry, I hear Neil. I get a sense that maybe we could just get a little more information on the status of it before we keep going. I just don't want to, what I really want to try to do is, as the chair, is not create situations that put our decision-making as a board in any jeopardy, and also the village in any jeopardy for
Of course.
litigation. And it's not that I don't respect or care about everyone's opinion, I do. So that being said, I think maybe the best thing to do is just check on the status of that particular application, and then we can see where that is.
I was actually asking a generic question, which is, what is our role as the planning board in the process of changing from one allowable use to another allowable use within the business district?
Right.
Do we have a role in that?
I think to the extent anything changes with respect to triggering parking or any other changes on the site, you have a role with respect to site plan approval. And you would have to review the site plan approval, review and approve any site plan amendments due to the change from one permitted use to another. So that's
like
just...
For example, when we've discussed in the past changing from apartment to office, if it's a permitted use, it's a permitted use. The only thing we can consider is the parking variance, which in that case is usually very small, and then it goes over to the zoning board to determine whether or not to grant that variance. But as far as other uses, it would be a similar, analysis of the situation.
Yeah, I think it's a good discussion to have offline about this, about the ordinance in itself, because that use that they are putting in there is an allowable use within the village business district already. So but I do agree with Larry that we should probably have a conversation about our role in some of these changes. But at this point, the way the ordinance, if it's
Yeah.
allowable in the business district, you can't deny it just based on.
That's my real question is, what is the allowable use that it's being changed to?
We'll have to figure out the status of this and get back to you, sir.
Let's get the details on that, and then maybe that'll clarify things. Just to circle back to the bigger picture, the waterfront overlay district, some of these issues were attempted to be addressed on a global scale, which is how they really need to be. If you're going to change the code and look at permitted uses on a granular level, and that was adopted, but I don't think that the table of uses changed in any significant way. Is that right, Kathy? Or
It did not change.
It did
Right.
not change.
No.
but just so you guys are aware, it was extensively discussed and proposed by that waterfront overlay committee.
Yeah,
I mean,
I'm aware. I was
yeah.
aware.
So, and I mean, I hear and maybe not even frustration, but the concern and the questioning, and I think it's valid. But aside from doing it on on a code level, we just can only clarify what some of these uses are, and or refer to the building inspector, and or follow the code and making an analysis on if it's a permitted use or not, and making the appropriate referrals if it's something that's going to affect septic and all those other issues for site plan approvals.
Right.
So, but let's get some more details on that one, and we'll circle back, and hopefully, Larry, you can talk to the building inspector in the meantime, or maybe we can answer the questions and then take it from there.
Well, I will just make one last comment.
Sure.
The reason why I'm concerned is not because I'm opposed to anything. It's because this group came before our board for what reason? To give us information or get some feedback. And basically what I'm being told is we don't have any further role. On the other hand, they're in the middle of a build out right now, even as we speak. So who made a decision about what to go ahead?
Mm-hmm.
Whose role is that?
That's the building inspector's role. So
and
generally speaking, the building inspector gets an application and determines what review is required by different boards and whether or not he can issue a building permit. So we'll definitely follow up with the building inspector on this matter and follow up with you as well.
Okay.
Yeah, and at a minimum, we could examine our own internal policies. If the building department determined when they saw the application in the first place that it was an allowable use, why did it come to us if we had no role in determining anything once it's been declared an allowable use? So, it's just, that to me was an annoying experience, which it seems to me, it sounds like there's an answer, and the answer is we don't get those dog and pony shows.
Well, I think to Neil and Larry and everyone, I'm still learning about how to lead properly, and I appreciate, because Liz has given us a new perspective. I think my inclination is that we really follow the procedures correctly, and we follow the code, and that sometimes in the past we would have more informal discussions. There was a time about some of these things, and it seemed it seemed helpful, it seemed impactful, but it probably wasn't necessarily legally correct. So there's a bit of a shift here, and I think we're not going to entertain as many of those discussions in meetings unless there's a formal application, because it legally doesn't make any sense for us or the village to go through the process without a more formal application. Does that sound right, Liz, to you?
Yeah, I mean, my job is to make sure the record on all of these applications is clear and appropriate and legally something we can uphold in a court, right? And so, we don't even have an application before us right now, and you're talking about a specific property, and that's not a good idea for a lot of reasons. But if you have questions, it's fine, and we can certainly go back to the building department and ask those questions and get them answered. Yeah. It's just like I said in the beginning, you want to make sure if you're talking about a specific property or an application, that the actual applicant or property owner is before you as well, and that you have some authority or jurisdiction over taking action over that. Otherwise, you're kind of wasting the board's time and or applying, looking at an application that's not before. It just doesn't make it doesn't make sense. It's not a good practice to have discussions. But you can ask for training if you do want more information about what elements you can look at pursuant to site plan and pursuant to your site plan authority granted to you by the New York State village law. We can absolutely go through that and look at those, as well as all subdivision authority. We can review those as well if you think it might be helpful, because you do have a lot of authority as a board. You're authorized to look at site plans and subdivisions pursuant to New York State village law and all of the enabling legislation that it authorizes you to take, all those actions it authorizes you to take.
What can I say?
All right.
Sorry.
Well,
Interrupt someone.
you have a question, Megan?
Yeah, I just wondering how I can better understand like which applications are going to be discussed. I mean, I got the agenda and I looked at it, but there was an email about something on Bay Street that I thought was maybe going to be discussed today, and I'm just wondering how to like better stay on top of or just like be prepared for what we're going to talk about.
Yeah.
The agenda should be what dictates what the board is going to discuss and review.
Okay, and every other thing that I get emailed, I'll just like save and keep it
Yep.
for later.
Yeah,
Okay.
you can do that.
Probably a good way to approach it. And because that other application will probably be on next month for some sort of discussion, maybe not.
That application, is incomplete at the Harbor Committee, so.
I think it's
Yeah.
a good
I'd
analogy.
rather not start talking about other applications.
Sorry, Liz, yes.
So basically, it's
Goodness.
here's my analogy. It's like a court docket, right? A court system might have 10,000 cases, but the docket for the day has 100, and those are the only ones that are discussed in court that day, and even ones where parties don't show up don't get discussed. They either get rescheduled or dismissed, and it's sort of the same with us.
Yeah.
And I think the takeaway too, though, is that if we have an application and we're talking about it and it's on the agenda, we can go through and ask questions and dig deeper.
Yes.
And that's what we should do as a board.
Absolutely.
Oh, yeah.
Okay.
All right. Well, I do, again, appreciate everyone's time this evening. I'm looking forward to seeing everyone in person next month.
Yes.
I really am. And so with that, could I get a motion to adjourn?
Yeah. Move.
And a second?
Second.
All those in favor? Aye.
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 So carried. All right, everybody. Have a great night.
So,
Good night.
Night, everyone.
Have a good night.